The employer just can't say, no, we're not doing that. Hi friends, welcome back to Disabled to Nature, and our National Disability Employment Awareness Month extravaganza continues. Today we're going to be talking about employment protections under the Americans with Disabilities Act, or the ADA. If you live in the United States, you might be familiar with the ADA, but did you know that it's more than just ramps? The ADA's 5 titles provide a lot of protections against discrimination for Americans with disabilities in a variety of facets of life. But today we're going to be talking about Title I, which covers employment. As you can imagine, people with disabilities experience a lot of discrimination in the employment realm. And Title I of the ADA was created to help combat some of that discrimination and provide protections for employees with disabilities. The purpose of Title I is really to level the playing field and allow people with disabilities to engage in the same kinds of job opportunities as non-disabled people. So since I am a policy nerd and I enjoyed doing it so much in the last episode, I'm just gonna read straight from the ADA for you today, and we'll interpret what it says as we go along. According to the law, the purpose of Title I of the ADA is so that no covered entity shall discriminate against a qualified individual on the basis of disability in regard to job application procedures, the hiring, advancement, or discharge of employees, employee compensation, job training, and other terms and conditions and privileges of employment. Basically, what this means is just that employers cannot discriminate on the basis of disability. They cannot treat a person with a disability or medical condition differently than they would treat a non-disabled person or someone without a medical condition. Before we move on, let's cover what the ADA means when it says a person with a disability. And I want to cover that because I think that a lot of people don't necessarily consider themselves as being a person with a disability or a disabled person because of all of the stigma and the internalized ableism surrounding identifying with that group. It happened to me. It's fine. It happens. But so I feel like there are a lot of people that can be covered under Title I and have encountered situations in employment that would have been protected under Title I that they don't think about. So here, in all parts of the ADA, including what we're talking about today, disability is defined as, with respect to an individual, a physical or mental impairment that substantially limits one or more major life activities. What's a major life activity? They tell you. Caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. So basically, if you have a condition that affects anything that you do in your daily life, the ADA considers that a disability. Congratulations. It also includes if you have a condition that impairs a major bodily function, like your immune system, cell growth, digestion, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. So like someone with, say, endometriosis might not consider themselves as a person with a disability, but if their employer, say, tried to fire them because they had to take extended leave to get surgeries or treatments or because of the symptoms of endometriosis, that would be covered under the non-discrimination clauses of the ADA. Is clauses the right word? I don't know, but you get the point. That's covered. So as we move along in our discussion, when I say disability or medical condition, these are all of the kinds of things that if you have it, you are probably covered under Title I of the ADA. Actually, the ADA in general, because this is not just for Title I, this is for the whole thing. And obviously, if you live in the United States. If you don't live in the United States, this doesn't apply to you, and I'm very sorry. Okay, so now that we've covered that, let's return back to Title I and that general rule. We're breaking it down. Basically, it means that employers cannot discriminate against someone with a disability or medical condition, and they can't treat them differently than they would treat someone without a disability or a medical condition. So if you think you've ever been not hired because of your disability or medical condition, that's a problem under Title I. If you think that you've ever been passed up for a promotion because of your disability or medical condition, that is a problem under Title I. If you think you've ever been fired because of your disability or medical condition, that is a problem under Title I. An employer cannot pay you less because you have a disability unless they have a 14C certificate, which allows them to provide sub-minimum wage to certain kinds of people with disabilities, but that's like a whole other thing that hopefully we're gonna get to later this month, but not in this video. I think one of the most important subsections of this rule is subsection 5, which talks about, well, let's just read it. Subsection 5 says, discrimination includes not making reasonable accommodations to the known physical or mental limitations of an otherwise qualified individual with a disability who is an applicant or employee. Let's talk about what reasonable accommodations are for a minute. A reasonable accommodation is any alteration to a job, your environment, or your job duties that helps a person with a disability complete the essential functions of that job. Essential functions are basically just that. They're the essential reasons for that job existing. So I'll give you a good example of something that is very commonly put on job descriptions and is not always an essential function. And it's the must be able to lift up to 50 pounds criteria that's on a lot of job postings a lot of the time. This might be an essential function of a job if you're working in, say, construction. It is likely not actually an essential function of a job if you're working a desk job in an office. So say you were working an office job and this 50-pound thing was on the job description. You can't lift 50 pounds. I can't lift 50 pounds. I have muscular dystrophy. I can't do that. So a reasonable accommodation might be, hey, if I ever need to do that, say I need to move some heavy boxes once every 6 months, a reasonable accommodation might be, okay, we'll get someone to help you with that. Whereas in construction, you probably would have to be lifting 50 pounds many times a day, and providing an accommodation for that would not be reasonable because it's an essential function of the job. And taking that out of the job description would be something called a fundamental alteration. So in general, reasonable accommodations are things that can be changed about a job without making a fundamental alteration to the nature of the position. Reasonable accommodations can be so many things. I think that it's a really great opportunity to get creative and think about how, especially if you're an employer, to think about how you could change or accommodate a job situation to make it so that a person with a disability could perform that job. There's something called the Job Accommodation Network, or JAN, which is basically a resource that helps people brainstorm different kinds of creative accommodations for different kinds of disabilities. I will link them in the description below. The next question people usually have is then, that sounds great. How do I get a reasonable accommodation? I'm glad you asked. Employers are required to participate in something called the interactive process when it comes to providing reasonable accommodations for their employees with disabilities. And this basically just means like there needs to be a conversation. If the person with a disability or medical condition comes to their employer and they're like, hey, I need this piece of equipment, the employer just can't say, no, we're not doing that. I mean, they can say no, but they have to like provide a reason and then try and help brainstorm with the person like different, perhaps more reasonable accommodations to help them perform the duties of their job. So say like you're a wheelchair user like me, and the company that you work for has like regular employees working on the second floor and managers and things working on the first floor, but they don't have an elevator. You could ask them to install an elevator, but probably depending on the size of the company, this is going to impose what's called an undue hardship, which is like a whole thing. It's defined in the ADA, but we're not gonna go into it. But they could say no to that, but they can't just say no and then like fire you because you can't get to the second floor where you're supposed to be working. But they could say, no, but we'll make an exception for you and you can work on the first floor with the managers. We have a ramp to the entrance. The first floor is accessible. You can work there. That would be an acceptable example of the interactive process. Does that make sense? When I talk about this issue with people, a lot of the times the thing that they're most worried about is disclosure to their employer. Many people are rightfully concerned about people knowing about their conditions, especially if they have a less obvious disability. Like I use a wheelchair, I'm not hiding that from anybody. But say you have like ADHD, at some point to get an accommodation, that is something that would need to be disclosed. So I want to touch briefly on disclosure. And in saying that, I want to say that in order to request accommodations, there is no official standard process for requesting accommodations. Generally, it just looks like a conversation between like you and your supervisor or you and HR and your supervisor. If it's an obvious disability like me, wheelchair, they're not supposed to ask you for extensive documentation to prove your disability because it's obvious. I use a 400-pound power wheelchair. But like I said, for someone with ADHD, that's less visible, and they can then require documentation for that in order to justify whatever accommodation it is that they're giving you. In that case, disclosure would be necessary to the extent that they need to know what you need and have like documentation and like proof that you need it. What they're not allowed to do is disclose your medical information to anyone who doesn't need to know. So that's like anyone other than HR and your like direct supervisor. Anyone other than that, if like your supervisor talks about your disability to a coworker, like that's a problem. You're protected from that under the ADA. In general, they should be keeping your medical documentation separate from your personnel file, and everything, all disclosure should be confidential. Disclosure is always voluntary, but you are probably gonna have to disclose at least some things in order to get the accommodations that you need. So now we know what are reasonable accommodations, how we get them, but when can you ask for them? And the answer to that question is anytime. If you have a non-apparent disability and you're not comfortable disclosing when you get hired or say in the first year of your job, that's fine. And then after like a year and a half, you feel comfortable and you feel like an accommodation could help you do your job better, at that point, you could disclose and ask for a reasonable accommodation from your employer. You can ask for them at any time. You are also entitled to reasonable accommodations at any point in the employment process. That includes applying for jobs, interviewing for jobs, and being an employee. So those are some basics of Title I of the ADA and what reasonable accommodations are. There are a lot of things that we didn't cover, like how to file a complaint and where to go to ask for help. There are so many resources, great resources out there. I will link a bunch of them in the description. But for now, I wanted this video to serve as just like a very, very basic baseline of what Title I of the ADA says and what it means. It's relatively short. Like in a PDF form, it's only like 4 pages, Title I. So if you're feeling so inclined, I think you should read it. I'll link it below if you want to read the actual text, because it's really not that bad, I think. If you have any specific questions about the ADA or anything else related to disability and employment, please put them in the comments below. I want to know. I want to see if I can answer your questions for you. Thanks for watching. Don't forget to subscribe for more thrilling content, and come back next week when we have a conversation about my disability employment journey and how I went from being a zoo animal welfare researcher to not being that anymore. Don't forget to get outside, and I'll see you in the next one. Bye.